welcome to Introduction to Criminal Justice, CJC 111. This is a completely online class, and this is the first of our video lecture series. What I'd like to do first is just make sure that you have the right book. So whether it is an online version or an e-version or an actual book you got from the library, let's make sure it looks a lot like this. See if I can take the glare off. There you go. This is the book that we'll be using. Criminal Justice Today, 16th edition. Criminal Justice Today, 16th edition. That's important. And what we'll start off by doing today is just touching on some of the topics that are in Chapter 1. We're going to cover Chapter 1 today and this week in general. What I have planned for this week is you'll have an exam, your Chapter 1 exam. You will have a discussion board, and that discussion board is separate from the discussion board that you may have seen me discuss in the introduction video or the welcome video, where I want you to introduce yourself. I introduce myself. You can introduce yourself either by posting a video like I did. You can put audio. You can upload that, or you can just write a few words telling your classmates and me about yourself. So I look forward to those, but we also have a discussion board that actually covers the content. And the content for this chapter and the entire book, one of the primary themes that you're going to see all throughout the chapters of this book over the 16 weeks that we'll be in this class is a battle between individual rights and public order. So that's the law, the struggle with the law. Because folks inherently want to do what they want to do. So, and you should have the right. Some say the God-given right, the constitutional right to do what you want to do, to have your freedoms, your individual freedoms. If you own a business, maybe you want to put a billboard as high as you want, a huge billboard in downtown. Should you have the right to do that? Should you have the right on your property that you own in downtown? Should you be able to put as large a billboard as you can with as many flashing lights as you can that bothers everybody, but it's your business? There's a struggle. A lot of municipalities, a lot of counties and cities make laws about the size of the billboard, the number of lights, or how distracting it can be. Because although somebody may have the individual right to put up a billboard, what about public order? What about how much it bothers everybody else? Maybe you want to put sound on that billboard. Would that bother people at night? Probably. So there's a battle between your individual rights and the public order. What about TSA? We talk about the struggle between safety and rights. So we all know that the Fourth Amendment protects us from unreasonable searches and seizures. You can't be you can't be searched with no cause or without a due process or enough cause, enough reasonable suspicion. But are you suspected of a crime when you go to the airport? I hope not. But you're still searched. You still have to go through a metal detector. Whatever those large electronic searching machines are called, they can see through your pockets and whatnot and see if you're holding anything, see if you forgot to take your keys out of your pocket, whatnot. You're being searched without being suspected of a crime, without reasonable suspicion. So is that unreasonable? Where's that line drawn? Where you have your individual freedoms to not be searched, but there's also public safety and public order that always butts up against that. And you have to find that line. Where does it sit? So those are two examples that I can think of off the top of my head that talk about that battle between individual rights and public order. What we're going to do this week in the forums, I want you to read a little bit more about the chapter. I want you to read a little bit about that subject in the chapter. We're going to see it, like I said, for the rest of the 16 weeks. But this week, your discussion board post is having you take one side versus the other and discuss that particular subject, individual rights versus public order. Now I just kind of want to change gears and talk about the criminal justice system. And that's what it is. There's a little bit of a debate in the chapter whether or not the criminal justice world is a system or a non-system? How much cooperation exists between all the categories and the aspects of the criminal justice world? Well, let's talk about what are the aspects. I mean, we've got police, courts, which include prosecutors, defense attorneys. It could be a government employee defense attorney. It could be a public defender. You've got judges, clerks that keep track of the caseload. From there, after the courts, you've got the correction system, which isn't just prison guards, it's not just jail employees. You've got probation officers and parole officers. So there's all these different moving parts that have to cooperate or should cooperate. Whether or not they do is up for debate. So let's talk about how somebody enters the criminal justice system or non-system. Usually it's by arrest. So do we need a warrant to arrest somebody? When do we need a warrant to arrest somebody? Well, warrants are usually necessary when somebody is not present anymore when the crime is being investigated. For instance, there are states where if a misdemeanor occurs not in the presence of a police officer, and that police officer later sees the person who committed that crime, we'll say misdemeanor vandalism. Somebody vandalizes a house. The neighbor sees who did it. They saw John vandalize that house and John took off. They called the police officer takes the report, and later, a week later, that same police officer sees John. Can he arrest him? In some states, no, because vandalism is a misdemeanor, and that misdemeanor did not occur in the presence of the police officer. So how does he arrest him? How do we take that person into the criminal justice system? An arrest warrant. So those facts, that fact pattern, the witness statements, the police report, any evidence, photos, those are all going to be presented to a prosecutor. And then that prosecutor is going to sign off and say, yes, I think we're going to prosecute this case. And then that package is given to a judge, and judge signs and says, yes, you can go arrest. There's enough to go arrest. Go do it. Otherwise, you don't need an arrest report if the person is still there. Or excuse me, you don't need an arrest warrant if the person is still there, right? So a police officer, take that same scenario. John is vandalizing somebody's house, and the neighbor calls the police. The police get there, he's still vandalizing. No arrest warrant necessary, right? The officer just arrests him, takes him to jail, and enters him into the criminal justice system. In the investigation phase, one thing I want to bring up, because we're going to discuss it again in upcoming weeks, is Miranda versus Arizona. So that's a Supreme Court decision. That's where the Miranda rights come from. So I know you've seen a lot about Miranda rights. If you're in law enforcement now, you're probably quite familiar with Miranda rights, but I want to give it on a basic level. So there are only certain times when Miranda rights are necessary. I know you'll see on TV and you see on movies where folks say, oh, the charges got dropped because they never read me my rights. I assure you, as somebody who's been in law enforcement, like I said in my welcome video, I was with LAPD for 22 years before I retired. I assure you, somebody with over 2 decades of experience in law enforcement, that Miranda rights are not always necessary. It's a very specific time when they are necessary. Somebody has to be in custody and questioned. If those two elements are not present, there's no need to read somebody their rights. If that officer, we'll use that same scenario, he rolls up and sees John spray painting, vandalizing a house, and he takes him to jail for it. If John doesn't want to ask any questions, excuse me, if the officer doesn't want to ask any questions of John, there's no need to Mirandize. There's no need to read him his Miranda rights. He saw him do it. There's no interrogation. So custody plus interrogation equals Miranda. So that's something to remember as we go forward into the other chapters. So let's talk about after the arrest. Processing, go to jail, then what happens? A night or two later, you need to make the offender The inmate needs to make an appearance in court, a pretrial appearance. It's called a pretrial appearance because there's no trial going on. Just because they go to court doesn't mean that there's a trial going on. The pretrial appearance is going to discuss what the charges are, because maybe the officer arrested John for felony vandalism, because in some jurisdictions, vandalism can either be a felony or a misdemeanor. If you do more than a certain amount of damage, more than $900 worth of damage, or $400 worth of damage, or if you vandalize a church, a place of worship, there are different criteria that will make vandalism a felony in certain occasions. So maybe what the officer arrested John for was felony vandalism. However, they went to the prosecutor, they presented the case, and behind the scenes, while John was in jail waiting for his pretrial appearance, the prosecutor looked at his arrest record, his rap sheet, and said, you know what, this is the first time John's ever been in trouble. Granted, he did vandalize more than $900, doing more than $900 worth of damage, but first offense, why don't we charge him with a misdemeanor instead? So now, somebody's got to tell John. Because all John knows is when he was booked for a felony. So he goes to his pretrial appearance, and that's when the actual charges are read, the charges that he's going to be charged with. So let's talk about the levels of proof, what is required to get past certain aspects of the criminal justice system. So if the officer wants to stop a suspect, not arrest, just stop, because he thinks that suspect may have committed a crime, that is what's called reasonable suspicion. The officer reasonably suspects that this person they're going to stop and detain has committed some sort of crime. It's a set of articulable facts that would lead a reasonable person to believe that a crime has been committed, is being committed, or is about to be committed, and the person to be detained is in some way associated with that crime. So that's a pretty broad definition. That's a lot of leeway for officers. But what if that officer wants to make an arrest? Is reasonable suspicion enough? No. You need to have probable cause. Did the person that you're going to arrest probably do it? Is one of the easiest ways that I use to explain that. Is there a reasonable probability that this person committed the crime? If so, then that's all it takes to arrest. That's the arrest standard. Does that mean they're going to be filed on? No. Maybe the prosecutor sees that case and says, sorry, we don't have enough to try. Why? Because that next level of proof beyond a reasonable doubt is a lot more difficult to achieve. Proof beyond a reasonable doubt. That's what's important. The reasonable part of that is what's important, because not proof beyond any doubt, not proof beyond, well, maybe aliens came and took over his brain and made him vandalize that house. Is that a reasonable doubt? No, that's just a doubt. That's just a story that somebody could come up as a defense. But if you can prove, as a prosecutor, if the prosecutor proved the case, what the officer saw, in this case, the story we saw, the neighbor saw John doing it, the officer saw John doing it, there's probably evidence of the vandalism taking place, and then John is in possession of whatever he was using to vandalize. So those are a lot of good factors that would make it very difficult to be unable to prove that case beyond a reasonable doubt. So that's what goes on. Not necessarily those levels don't go on in the pre-trial portion, but that's as the trial progresses. So once you have your pre-trial appearance, now all you've essentially done is, as an offender, you've had your charges read to you and bail has been determined. Because usually most jurisdictions have a bail schedule. So if you're arrested for misdemeanor vandalism, then your bail is going to be $1,000 across the board. However, once the judge or the prosecutor reviews the rap sheet, the criminal history, and says, oh, this person's been arrested for 25 previous and convicted 25 previous times for vandalism, I think maybe we'll increase that bail. Or they're on probation. So there's sort of other factors that can increase the bail. So the bail is going to be determined at that pretrial hearing. But what's next? The next step is a preliminary hearing or a grand jury. A lot of times grand juries are a different scenario because grand juries will take place when somebody's not in custody. So John is suspected of vandalizing the house. The neighbor saw him do it, and so the officers took a report. The detectives investigated that, found the evidence, maybe found some surveillance video of John doing it, but John's not in custody. John's at home. He left. So now you can, two options. One, you can run out and arrest John and see if the district attorney, the prosecutor wants to try that case. And if they do, then you arrest John, he goes to his pretrial hearing, then he goes to what's called a preliminary hearing, where that evidence is presented and rebutted by a defense attorney. And both sides are told, the evidence is given, the witness statements, the officer statements, the evidence, the surveillance statements all shown, or maybe not, maybe just a part of it is shown. And then the judge will determine, is there enough here? Is there enough in this case that this should go to trial? It's not beyond a reasonable doubt. It's clear and convincing proof. So if there's enough clear and convincing proof that the prosecutor can show the judge and not be reasonably rebutted by the defense, then the judge will hold that person to answer at the preliminary hearing, and it'll go to trial. But the other side, what about grand juries? We talked about, what about that time when John is not in custody and you don't want to go arrest him? You want to see if there's enough for it to go to trial before you take away his liberties, before you take away his individual rights, because it's a huge deal to take away somebody's liberties, right? So in that case, the prosecutor could convene a grand jury. The offender, John, isn't there. That means there's no defense attorney there. A grand jury is a jury of citizens who have volunteered to sit and hear cases and determine whether or not there's enough to do the same thing that the judge did in the previous story, in that preliminary hearing. Listen to the case and determine if it should go to trial. Is there enough clear and convincing proof? But I already told you one really key aspect there. I told you John's not there to defend himself. There's no defense attorney there. So how many sides of the story are being told? One. Just the prosecutor with nobody to rebut it. How fair do you think that is? It's legal, but how fair do you think it is? When somebody is found that, when the grand jury finds that there is enough clear and convincing proof that that person should go to trial, that's called being indicted. And there's a phrase that in the criminal justice system, it says, you can indict a breadbox. If you're only telling one side of the story, you can indict anybody. How much or how innocent does somebody have to be that when you tell one side of the story, that grand jury still finds that there's not enough to indict them? It's gonna be pretty rare, right? Because we've all heard one side of the story and believe that side of the story. It's not until they say there's two sides of the story, but if you only hear one of them, it's very difficult to not believe that side of the story. So that's how a grand jury works. And then if the grand jury does decide to indict in this case, John, then an arrest warrant is issued and John can be arrested on that warrant. So the next step, adjudication of the case. We got a few options. The main option is, or the most well-known option is that you go to trial after that. You're indicted, or the preliminary hearing finds that you're held to answer, and the next step, go to trial. The prosecutor says their side of the case to the jury, the defense says their side of the case to the jury, and then we see who wins. But that's a long process. An entire jury trial, there's no way that every case can go before a jury. We just don't have, in the criminal justice system, we don't have the resources. The vast, vast, vast majority, very high percentage of cases are adjudicated and disposed of, have a disposition prior to a jury trial. Very, very, very few cases ever go to a jury trial. We just don't have enough time. If you go to a courthouse, you'll see they're looking at sometimes, when I was in Los Angeles, 30 preliminary hearings a day in each courtroom. And you're talking about 18-story courthouses. Can all that go to, do we even have enough people to go to house the juries, to populate the juries? They can't, we don't have time. Jury trials take days and days, sometimes weeks. So what's our option? Plea bargain. Plea bargaining is an option. Give the offender enough incentive to plead guilty. Doesn't always work. Some people always want to, if they feel as though they are innocent, they're going to take it to the jury box and let the jury decide. That's their right, 100%. It's your constitutional right to have your case heard by a jury of your peers. However, in this case, John, he was arrested for felony vandalism. So whatever the exposure is how much time you can do in jail. Whatever the exposure is for felony vandalism in that jurisdiction, maybe 3 years. So 3 years is the maximum sentence that John can get for his felony vandalism crime if he goes to trial and loses. But the prosecutor tells him, you know what? I'll drop it down to misdemeanor. Misdemeanor vandalism. 2 weeks in jail. Now John's thinking, well, I know I did it. I don't have a lot of proof to prove I didn't do it. That's gonna be very difficult for me to get out of this case. I'm looking at 3 years, but they're offering me 2 weeks. Maybe I'll take that deal. Maybe that's what John's thinking. Maybe he'll take that deal. There's a lot of leeway with prosecutors in plea bargains. Doesn't even have to be jail time. Maybe instead of 3 years in jail, the prosecutor says, how about misdemeanor vandalism, 3 years probation. You never go to jail. Release today, just keep your nose clean and nothing happens. But if you don't keep your nose clean, you're gonna go to maybe a suspended sentence. Maybe they'll keep that 3 years dangling over John's head and say, if you get arrested again, you're gonna go to jail for what you did, plus these 3 years. There's a lot of options. But without that plea bargain system, without the ability to dispose of some of these cases, a lot of these cases, the vast majority of these cases, then the wheels of the criminal justice system would grind to a halt. But what do they say? With great power comes great responsibility. It's easy to abuse. It's easy to see how plea bargaining could be abused. You could give somebody somebody who is innocent, maybe it looked like they were guilty. Not everybody who's arrested is guilty of what they did. A lot of times, sometimes people are just appear to be innocent, that they appear to be guilty, and the evidence points towards them being guilty. However, later you find out additional evidence shows that they didn't do it. That happens a lot with the Project Innocence, or the Innocence Project, I'm sorry. DNA will later show that these people didn't commit murders, although a lot of the evidence said they did. However, if you give somebody enough of a sweetheart deal and they're looking at enough time, don't you think they're gonna take that deal a lot of times, even though they're innocent? So now you've convinced innocent people through self-preservation to take a deal that they don't necessarily agree with, but they don't want to go to jail for the rest of their lives. I know that in the John scenario, it's just vandalism, but there's a lot of time, if you're looking at a major crime and major crime comes major time, then maybe in that case, enough of a sweetheart deal is going to make somebody admit that they did something they didn't do. And then how easy is it going to be to appeal later? Everybody's going to say, well, you admitted you did it. Why should we believe you now? So those are the dangers of plea bargains, but they are necessary. It's a necessary danger because without plea bargains, like I said, the criminal justice system would grind to a halt. We just don't have the resources to try every single case. Sentencing. After so you take a plea deal, and from the plea deal or from the jury trial and you're found guilty, now there needs to be a sentence. The judge is going to hand down a sentence. So sentences a lot of times can be determinate or indeterminate sentences. So a determinate sentence would be, the judge will say, I sentence you to 25 years. That's it. It's determined, you'll do 25 years. All right, there's some parole leeway in there. However, indeterminate would be, I sentence you to 25 to life. Which is 25 or life, or somewhere in between. It's indeterminate. Minimum 25, depending on how things go. And there's a lot of factors in the correction system that'll determine how things go, parole boards and things like that. But that indeterminate sentence is very vague. The other types of sentences we have are consecutive and concurrent. So we'll take that John scenario again. So John vandalized the house, the felony vandalism of the house, and also when he ran from the police. Two different crimes: vandalism, and evading. So when John went to the initial pretrial hearing, both charges were filed, and that's what he was going to go to trial or plead to. Well, fast forward, so those, you've got, even if both are misdemeanors, maybe the exposure for a lot of times the maximum exposure for misdemeanor is 1 year. So 1 year on the misdemeanor vandalism, and as long as nobody got hurt in that evading, that pursuit, then 1 year on the evading. Is that 1 year? Or is that 1 and 1? That's the difference between concurrent and consecutive. If you look at that as one, the judge can determine within reason and within the legal guidelines. The judge would say, okay, we've got 1 year here and 1 year here. That makes 1 year. And that's how long he'll spend that time in jail serving both sentences at the same time concurrently. Or the judge can look at that and say, you got 1 year here, 1 year here, that's 2 years. You'll serve the first year first, the second year second, and then I'll see you in 2 years. That's consecutive versus concurrent. And then they go off to prison. So prison, it's got its own challenges, its own issues, obviously. What are some of the challenges with modern prison system today? Before, you hear a lot of things like folks, they go to prison and they get free college. They go to prison, they learn free skills, things that you and I may not get. Most people in this class had to pay for their classes. Is it fair for somebody in prison to get them for free? To get a college degree completely for free? Fair is a tough word. Because what about when they get out? They've already got the challenge of having that jacket on them of being a convicted felon, and now a convicted felon without a degree is 2 strikes. Maybe as a society, we want to help people not go back to jail, and that's why we're willing to pay and sacrifice for them to get a degree. Maybe not. Maybe we want them to learn a skill, learn a trade, so that when they get out, they can be a barber or whatever other trades that they learned in jail, so that they can not have to resort back to criminal activity to survive. It's a debate, but it's possible. However, in the age of lack of funding, what do you think has happened to a lot of those programs? They've shriveled up. A lot of those programs go away. Maybe libraries aren't as robust as they used to be. Maybe there aren't enough college level professors and instructors to teach in the jail system, in the prison system. Maybe there's not enough money to pay them. Now what happens? Now somebody goes to prison 3 years, 2 years, doesn't learn a skill, comes back out exactly where they were when they went in, except now they've got a longer rap sheet, and it's that much harder to get a job. I think it's human nature to look at somebody who applies for a job that you have a decision on hiring and you've got somebody who's been to jail and somebody who hasn't been to jail, you know, sometimes the person who's gone to jail is going to get a second chance, but a lot of times, if you're looking at all things being equal, one person's gone to jail and one person hasn't, you're probably going to choose the one who hasn't gone to jail and believe that they're more trustworthy for the job, and that's who you want working for you. And then there's places like California that's illegal. That question on an application, it's illegal to ask. It's called the ban the box program. California has said that box where it says, have you ever been convicted of a crime? It's illegal to put that on an application because they don't want the biases that go along with people who are making these decisions and only making that decision based on who's gone to jail and who's not. Sure, later on, if it's a sensitive type of position, then later on that position can be brought up, but in the initial screening phases, California specifically, and other states are jumping on board, it's illegal to ask that question, just so people coming out of jail, coming out of prison, can have a fair shot at employment instead of having to resort to criminal activity to survive. So as they come out of incarceration, there's a couple options. There's some options. So some folks can do their entire sentence. You did 3 years, your sentence is 3 years, they did 3 years, they got out, they're free and clear. Of course, they still got the jacket, they're still a convicted felon. But sometimes you're sentenced to 3 years, and after a year and a half, 2 years, you go before the parole board, and the parole board says, you know what, you're doing all right here, we're gonna let you go. But not without strings, there are catches. The parole, when you're sent out on parole, think of it like this. Parole is jail without the bars. Jail without the bars. You still have all the rules that you would have in jail, except for those physical rules where you can and can't go. They can tell you you can't go to a bar. You can't drink alcohol. It's not legal in general to tell somebody they can't drink alcohol. But if you're on parole, you're up to a whole nother set of rules. I can't walk up to you as a law enforcement officer. I can't walk up to you and just search you for no reason. But if you're on parole, I can. You give up a lot of your own freedoms and your own liberties in exchange for getting out of jail or getting out of prison when you're on parole. Something to keep in mind. It's give and take. So I've seen many occasions in my law enforcement career where people just can't stay out of trouble, and they know they can't stay out of trouble. They can't stay off dope. And they know if they walk down the street, they're going to have dope in their pocket, and if they get stopped, they're going to get sent back to prison. So what do? How do you avoid that? They already know they can't avoid the dope. So when they're in prison, they don't take the deal. They don't take the option to leave prison early and get out on parole. They do their entire sentence. That way, when they leave, they're free and clear. There's no additional parole conditions. Nobody can walk up to them and search them without cause. They can go wherever they want. So as long as they're actually not caught doing something illegal, it's a lot more difficult to detect them breaking the law. Know yourself. That's self-preservation. The other wing of those who are in the criminal justice system but not incarcerated is probation. So probation is something you are sentenced to in lieu of incarceration. So parole, at the end of, released early and you're out on parole with a lot of these rules. Probation is you never went to jail and you have all these rules. How does that work? John gets convicted of, gets arrested for the vandalism, the plea bargain. He takes, yes, I'll take it. I don't want to go to jail. I'll take your 3 years of probation. So the prosecutor and the judge will have a list of probation conditions. So if you want to avoid jail, here are the things that you got to do, John. You got to do 40 hours community service over the next year. You've got to take some anger management lessons. Can somebody just force you to do anger management lessons? No, not without being in the criminal justice system. But if you elect for probation, that can happen. It's legally binding. Fines. You have to pay those fines. And then there's search conditions. So maybe part of the probation is that the judge says, you know what? I want you to stay out of trouble, John. I know that this was a drug-fueled crime. You were high when you did it, and I know you're addicted to drugs. You got to go to rehabilitation, and also you have search conditions. Any time of the day or night, a police officer can stop you with or without cause and search your person and your effects, your belongings. So legally violating somebody's Fourth Amendment rights because they elected to take the probation. Because that's the catch. John doesn't have to take probation. He can still go to trial. He doesn't have to take that plea bargain. He can go to jail instead. So this is, a give and take. If John thinks he can stay out of trouble and won't get caught with dope in his pocket or burglary tools or vandalism tools in his pocket, then maybe it's a good deal for him. I don't know. So that is an overview of chapter 1. Make sure you read chapter 1, complete the test, do both forums, the fun one, the introduction one, and the substantive one, and make sure each of those forums has at least 300 words in the initial post and 2 replies of 150 words each. The initial post is due on Wednesday, and those replies are due on Sunday night. If you have any questions about that, make sure each of your each of your posts has at least 2 outside references. It could be the textbook, it could be this video. Make sure you cite and use APA format when you do it. I'm not going to sway you too much because I know the forums are sometimes a little difficult to use to format in APA, but show me that you tried. If your spacing is a little off, I'm not gonna sweat you about that. But if you just cut and paste a link to something, that's not formatting. Okay? I look forward to reading those, and you guys enjoy the rest of your week.